Yes.
Yes. Introduction of the speaker कौन करेगा?
Nobody. Because there's no speaker. No speaker.
Okay.
Okay, so yeah.
We'll start.
Let's start. Yeah. So good morning, everyone, and welcome to today's SMS. As you all know, Saturday morning sessions. They are also known as, strong meditating sessions. I think now that's what one of the members told me. It appears that when we are in SMS, we are doing meditation on GST because कभी कभी तो मैं सोचता हूँ for 7 years what I have been understanding is wrong. Today I've got a new perspective. So I think from that angle, it's also about meditation. So now coming back to the discussion that we're going to have today, it's as if we all know that the finally after 7 years, the wait is over. The tribunal is in the process of formation, and its signal is that the rules, GST Appellate Tribunal rules, they have come into place. So a thought was placed by the admins that what is the requirement of having maybe why we should discuss the rules. We should discuss the rules because they are totally divergent from the to a certain extent that to the rules that we normally are following in the ITAT, CESTAT, or for that matter in the VAT appellate tribunals. Because I appeared before all the three, and I feel that the rules in some quarters they have taken a total diversion from the earlier fields. Some of the areas which have been included are beneficial to the taxpayer because they'll reduce litigation, like the area of counting the days which should be left. That way we have to follow the General Clauses Act. The fact that if the last day of filing falls on a holiday, or even there are 3 consecutive holidays, like in West Bengal, we have during pujas 5 days of running consecutive holidays. So if your last date of filing falls on a holiday or a series of holidays, you get that buffer that for all those days the deadline or the limitation will not be counted. So for this, since the advent of online filing, this was a common grievance by the tax professionals and the taxpayers that why should I work? Even there was a matter also on this part that I don't remember, I think Allahabad High Court, that 15th August is a holiday, right? For everybody, public holiday. So if my last date is falling for a notice, for a reply to a notice on 15th August, or appeal date is falling on 15th August, why should I sit in front of the system and file that appeal or the reply to the show cause notice or carry out any act? So that is a divergence that has been taken. But having said that, there are some certain things that we as professionals need to take care, because the responsibilities of the authorized representative, they have been enhanced to a larger extent. Okay. So now certified copy definition that needs to be taken due cognizance by all of us. So without much ado, I'll just go ahead, prepared a small presentation, but I think we should go straight to the rules. Yeah. Then I'll go to the presentation, like at the end, maybe for 10 minutes. Yeah. So these are the rules which are there. I'll go to page 32 directly because that's where the English part starts. Yeah. So we'll not go clause by clause because many of the things are like omni understandable. You can understand it just like that. So of course, the power is coming from section 111 to frame the particular rules and the rules that are being implemented. So these rules are known as the GSTAT rules 2025. Act, Adjudicating Authority, Appellate Tribunal. I'll not go to get into all these definitions. In the Act, in one of the sessions, I'll not say sessions, in one of the discussion things that we had yesterday evening, a question was asked that Arupji, isme Act में they have only told about CGST and state tax. Why IGST or and the UT tax? Why IGST is not given cognizance in this particular rules? The reason for that is that even if you see the appellate rules also, the appellate rules we follow, in the IGST Act, the appeal, they are coming on 107 only. So similarly for the tribunal, they are coming on 112. So that's why in the Act, nowhere the word IGST is being mentioned. Going by adjudicating authority, it's the same definition that we draw from the kind of CGST Act. Okay, because here it said the act will come again and again. So now I quickly go to the definition of authorized representative. So because on this, I think we need to have a few discussions because this will be important in the discussion of the definition of certified copy. So authorized representative in relation to any proceedings before the appellate tribunal means a person duly appointed by the central government or by the concerned state government or by an officer duly authorized in this behalf as authorized representative. So as we all know, even the functionality that is standing as on date, if you are following the CESTAT or the ITAT or the VAT tribunals, what happens is a person is first appointed by the central government or the state government to be the departmental representative. Okay, so he is appointed as a person to be the departmental representative. And then there is a second set of scenario, which is like a DC legal, or in our case, say in the state, we have a ADC legal. So ADC legal, sir, he is the officer who is duly authorized, okay, who is duly authorized in this regard through a proper notification to appoint, you know, the authorized representative who will appear, plead, and act for the commissioner in such proceedings. So ADC legal, sir, is again appointing the advocates, okay, to appear before the different forums. So similar thing, similar analogy is being drawn in the GST appellate tribunals. So ideally, the state government will appoint the DRs, central government will appoint their DRs, or even the say the officer who is duly authorized in this behalf. Like in our case, I've given the example of the ADC sir, who appoints maybe the representatives, the advocates who are going to act as an authorized representative to appear, plead, and act for the commissioner in such proceedings. So, of course, we know this background, but for people, for maybe a few members who are not aware about this, it normally what happens is when an order is passed, if it's in your favor, if it's against you, then it's okay, you are going in appeal. But when it's in your favor, the department thinks that it's prejudicial to the interest of the revenue, or maybe there is some revenue leakage, the department, through the authority of the commissioner, so commissioner sir or ma'am, they can go for an appeal before the appellate tribunal also. When there is the first appellate authority is giving a decision in favor of the taxpayer. So he will carry out the review. He will have a reason to believe that the appeal should be filed, and accordingly, based on that, normally the appeal will be filed. So here the authorized representative will be appointed by these three functionalities. Now coming to the part of the professionals, a person authorized in writing. So a person authorized in writing or through a wakalatnama. Wakalatnama is coming from the Advocate Act. So if you're an advocate, you cannot represent on the basis of an authorized writing, which is a power. You have to get a wakalatnama. If you're not an advocate as per the Advocates Act, then what you need to do is you can have an authorization. Okay. Duly stamped, and here the word duly stamped is as per the Stamp Act of the local laws of the particular state, whatever the particular state prescribes for addressing that particular document. It's different from different states. So by a party, so party is also defined here later on, so we'll discuss that also. By a party to present his case before the appellate tribunal as provided under section 100, as provided under section 116 of the Act to appear, plead, or act on his behalf in such proceedings. So here, the first part is easily clear. Second part is about the stamping. Third part is basically to present his case before the appellate tribunal through the three acts. That is, appear, to plead is when you are filing the submissions and arguing on behalf of them, and also to act. You're furnishing some document, you're collecting some notice, you have been given some discrepancies. So all these things. So you're acting on behalf of the party in this case. So you can do it only through the authorization of the wakalatnama that has been given. So 116, what does it say? It says either a relative, okay, or an officer or an employee of the person, or a practicing chartered accountant, company secretary, CMA, or an advocate. So the first thing that emanates from the definition 116 is that, if I'll just like to stop sharing here because 116 also needs some bit of discussion here, then we can go again back to the rules. In between, if there is any thing that you need to add, please do add, because it's not a thing. So please do add if anybody wants to share something on this. I'll just quickly take section 116. Yes. Yeah. So 116 says that any person who is entitled to or required to appear before an officer appointed under this act, or the appellate authority or the appellate tribunal in connection with any proceedings under this act, may otherwise, and when required under this act, to appear personally for examination on oath or affirmation subject to such other provisions of this section, appear by an authorized representative. So either the taxpayer can appear, or on his part, the authorized representative is also allowed to appear. Now, the second part is, for the purpose of this act, the expression authorized representative shall mean a person authorized by the person, so his relative, to appear on his behalf. So first is his relative or regular employee. So if it is his relative or regular employee, there is no bar on his appearance before any of the authorities. Okay, so he just has to have an authorization saying that he's a relative of the taxpayer, or he's a regular employee. Please mind the word, it's a regular employee and not a part-time employee. So if I'm an accountant working in 10 different places, so I cannot say that I can be an authorized representative for that particular taxpayer. Next, where we are facing the main issue, where we have already represented to the government also on this, which is, it says, any advocate who is entitled to practice in any court in India, okay, on any chartered accountant, a cost accountant, a company secretary who holds a certificate of practice and who has not been debarred from practice, a retired officer of the commercial tax department. So we are not getting to that D part. Main part that we are trying to discuss is about B and C. So if you see the wordings, it's only about a chartered accountant or a company secretary or a cost accountant who is in practice, and also an advocate in practice. So what would happen to the team members who are working with the law firms or the CA firms or the cost firms or the CS firms? So in West Bengal specifically, we have faced certain issues wherein our team members, they have not been allowed to appear. Okay. So that is again one aspect. So with the coming out of the tribunal, so because in the CESTAT, I don't think we had such issues. But here in the GST appellate, in the GST Act itself, in the definition of 116, only practicing professionals, they have been included. So that is one aspect that needs to be seen, because even the GST appellate tribunals, they rely on this particular section here. So what would happen? I'm not sure about what is the challenges that may be facing in the other states, but at least in West Bengal, for some of the state tax authorities, we are facing this particular issue. We have already addressed this issue, but say we have already raised this issue, not addressed this issue. We have already raised this issue, and if in the other states also you are facing the same thing, because you have to understand the perspective. With GST litigation going far and wide, we are traveling also to a huge extent. So it is not possible that a particular professional could be present in all the places at the same time. Though we know that virtual hearings are also being made available in many of the states. But having said that also, where you need a physical presence of maybe 2 to 3 hours, say you're sitting in a particular tribunal for 2 to 3 hours, at that point, attending another virtual hearing becomes a huge challenge. I was just speaking to one of the senior advocates recently who was appearing before the Calcutta High Court, and he was sharing as to how, because of all the noise that was there in the High Court, the judge, the learned judge, where he was appearing virtually, the learned judge could not hear him properly, because of which his matter was adjourned to the other day, though it was a very simple matter. So I think this is one part of section 116 that needs to be taken care of. Until now, since it is only at the adjudicating authority, appellate authority levels, the things have not been taken shape to that extent. But at the tribunal, I'm sure this thing will be followed very strictly. So we need to understand that before the things come in, what will happen. So we'll go back to Venuji first. Venuji, over to you.
I also want to discuss on part-time practice.
Yes.
There are people who are in practice, but also doing CFO services and other things attached to the corporates. So the institute
Right.
marks them as a part-time practice. That is also one point people have to consider. I don't know what happens to that.
Yes. So to add to this, I will not name some of the firms from whom I get the briefs. So what I am seeing is that some of the big firms, so what they are doing, they are asking their employees to take the COPs just to take to find a solution to this 116. Because if the employee is appearing on behalf of the firm, on the behalf of the CA firm, he cannot represent. But as soon as he has a COP, he can say that he's a practicing chartered accountant. Now, being an employee, practicing, having a COP, how that culminates, maybe as you have rightly shared, it will be a part-time practice only. So that is it. But what has been shared here as you see in 116, it's about a chartered accountant who holds a certificate of practice. So they have not said it's a full-time practice or a part-time practice. So I think even if you are having a part-time practice certificate, so that will entitle you to appear on behalf of the particular taxpayer as an authorized representative.
Yeah, I agree with the view.
So this is to discuss about authorized representative, because this is the problem area that we see coming in the days to come if this is not addressed properly. Next, I would like to go. Next, I would like to go to certified. Yes, sir. Yeah.
Hello.
Yeah, please go.
There's one question on this full-time practicing authorized representative and his
Sir, आपका
employees.
नाम तो बहुत बढ़िया है सर. Temple Run.
Sorry, it's my son's
Anyways,
ID.
please go ahead with your question, sir.
Yeah. So I'm saying on the practicing chartered accountant or advocate, whether employees can appear or not. To my mind, when the authorization is given to a particular firm, including the employees and the senior, it should include everybody, to my mind, and not restricted to particular individual as such. And if
No,
not, how do
that is
we
not the
come out of
interpretation.
this issue?
No, that is not the interpretation which has been taken. I have spoken to 3 commissioners of state actually. All of them have taken the consistent view, where I was just addressing the grievance that this is a problem. Sir, say I'm from West Bengal. Now I have to go to Odisha, I have to go to Tripura, Jharkhand and all these places to appear. So it's not always possible. So I have to send my team member to appear and all. So but the learned commissioners, sirs or ma'ams, their view is that अरूप जी इसमें क्या बोला गया वो देखिए. A chartered accountant who has a practice, authorization chartered accountant को देना पड़ेगा, not to the firm. They're not saying a practicing CA firm. They're not saying a practicing advocate firm. They're saying a practice. If I have to just 1 second, I'll just go back to 116. Sorry. I'll just go back to 116 once. If you see the words, the interpretation consistently taken by them is that only. So it's taken here, any chartered accountant, a cost accountant, or a company secretary who holds a certificate of practice and who has not been debarred from practice. So, आप debar कौन हो सकता है? The CA, who can hold this, who holds a certificate of practice? Only the chartered accountant or the cost accountant. And here the word used is a. It's a singular, an advocate. Okay. So what you're saying, that view is okay, wherein what we can have is, like we can have a CA firm where maybe we have 6 practicing CAs there, and we give the name of each of them. So everybody is authorized. But everybody who is appearing before the authority, that's the view which has been taken by the department. Because even I am of the view that you are taking, sir, that if once, I get the authorization in my name, any of my learned, associates, they can go ahead and they can appear. Okay, so next is Sujata ma'am is asking about a particular question, that how in the big fours, how they don't hold the COP, how do they? Yes, That's what I'm telling, ma'am. In Sestat, we don't have this problem. In Sestat, as per the Sestat rules, they don't say this particular area. So there, even an employee, like my team members, they go and appear. So that is not a problem there. Only thing is that the problem is about when you are within the GST Act, they have categorically mentioned that only a chartered accountant who holds a, or a company secretary who holds a certificate of practice, they can appear. So that's why we are having the challenge. So Nilesh ji is also saying large firms are employees are taking COP, right?
So just
Yeah,
to
I
share,
think
when I was working with LKS, that time none of
yes,
us were on the payroll of the firm. All of us were on hired on contractual basis, and I think
yes,
therefore they try to, try to address this problem which might occur in the courts.
exactly. You're 100% right. That's the structure which has been taken by many of the law firms actually. Okay, now coming to another important definition, which is certified copy. We have to be very careful. I would seek your attention here because this is going to be a big change for us. Certified copy means the original copy of the order. ये तो समझ में आता है कि it is uploaded on the portal with the DSC, or maybe you have got the original copy which is duly signed, which you used to get even in service tax and excise and all. It is always there. It was there, or the documents received by the party. So what could be the documents received by the party as per the house? Here it said, I'll just read the complete definition first. Means the original copy of the order or the documents received by the party or a copy thereof duly authenticated by the concerned department or a copy duly authenticated by the authorized representative of the appellant or the respondent. So original copy of the order, we are very clear. What do we mean by documents received by the party? Here it means, suppose you had got ASMT 10, you have got DRC 1A, you have got INS forms, you have got summons, you have got the RUDs. So everything, say that is not part of your original copy of the order. Okay. So all those things, they will also be part of the certified copy. Means whenever you are submitting such documents, okay. So either the original copy of the, you have to say if it's the original copy of the order, so that is okay. That is, there is no problem of that. You are giving the original copy of the documents received by you. That is, you are giving the original summons, you are giving the original INS, you are giving the original ASMT 10s. By original here we mean either digitally or originally signed or physically originally signed. But the second leg, which says, or a copy thereof, of or both of these things, duly authenticated by the concerned department. So you have to go to the department and take the signature, I think, which is a Herculean task. So which is a easier task? Or a copy duly authenticated by the authorized representative. So now it is on us, the authorized representative, who is going to appear, plead, or act on behalf of the taxpayer, of the party basically here, to authenticate all these documents. So imagine now the kind of, till now, till date, all the Sestat filings or whatever VAT tribunal filings or whatever we have done, I'm sure at least 80% of the house will agree with me. We never authenticate the copies until and unless it is a super urgency. Okay. At the most, maybe sometimes when we are told that, okay, kind of submit this thing in addition. So this 3 copies. So I don't, at that point of time, I don't go back to the client. I just do the signature and give it in the tribunal to the DR. So those are the things that happen. But till, if I would like to know from the house, till now, when you are filing the appeals, even before the first appellate authority, or when you are appearing before the tribunals, are you authenticating all the documents?
Sir, this was a very common
No.
practice. Every document was authenticated order passed
By
the
by the
by
whom?
by ACDC edition OIO.
नहीं, that is okay. वो तो है, by the department
OIO
अगर
is
मिल गया वो तो,
okay.
हाँ.
OIA was never authenticated.
No, I'm saying that part is okay if it is done by the department, वो तो problem नहीं है. I'm saying, have you ever done it as a representative? When you're appearing before, मान लेते हैं आपके क्लाइंट के केस में सर्विस टैक्स का मैटर है और आप
Hmm.
सेस्टेट में फाइल कर रहे हो, सेस्टेट में आप
Yes.
1000 डॉक्यूमेंट फाइल कर रहे हो, इसमें से ऐसा भी है कि अराउंड 200-250 जो है आरयूडी है, ठीक है ना,
Hmm.
मतलब डीजीसीआई का केस बना था, स्टेटमेंट लिया था, बहुत कुछ हुआ है, सब कुछ आरयूडी में है, और अभी जो है ऑर्डर आपने फंड किया और उसके साथ ये ऑल्सो गिवन द कॉपी ऑफ द नोटिस, द आरयूडी, द समन्स एंड एवरीथिंग. तो आज तक हैव एनी ऑफ अस साइंड ऑल दोस डॉक्यूमेंट्स, all the
Other
documents
No
than
signed?
way.
OIO, nothing.
No way. No
Normally,
way.
it is done by the taxpayer.
OIA is only authenticated, that too on one last page.
हाँ, so नहीं, I'm saying जो भी है, मतलब documents, I don't think anywhere it was a responsibility was cast upon us, the authorized representative, because when you are saying that duly authenticated, मतलब now you have to go back to the portal, say the thing is not DSC signed, and you are, so normally which we are facing, say in the high courts we are going for many of the petitions where we are saying that the DRC 01 is not signed only, okay, and they have given it without signing and all. So now you have to sit back and check the DRC 1 जो client ने आपको दिया है, and whether the thing in the portal is okay, or you have to engage your person, get it down from the portal and to the signature, along with, now suppose in all this alleged to be fake credit matters, so we are getting voluminous copies, okay, so many statements being taken and all. So are we as authorized representative supposed to verify the veracity of all those documents? So that is one question. And I feel, since we have taxpayers from across India here, this is something that we should represent in each state. That
Arup
the
ji,
authentication should be done by the taxpayer, not the authorized representative. Or at least an option should be given. Why is
Arup,
it only by the authorized representative?
Arup ji,
Yes, sir.
Arup ji,
Huh.
there is a concern that I think that much stretching is not required, that each and every document is required to be authenticated.
वो तो बोल रहे हैं सर यहाँ
Because
पे.
nahi, there are two questions in your question. One,
Yes.
each and every document is required to be verified by a chartered accountant or an advocate. Answer to that question is definitely yes. Because if anything goes wrong, then that representative or advocate is answerable to respective bench. So document have to be genuine. Any fabricated document is given by client and you just put up before the bench, then it is a then it is a very immature practice that you are not even verifying the documents before putting it before the bench, because DR is going to definitely ask this question whether this is a document is genuine or not. Right. Now coming to
Right.
the authorization of the document.
Hmm.
As far as authorization of documents are concerned, they just meant to see in tribunal, in C state we have faced this. They just mean to see that all the documents are verified by you. Not each and every document is signed by you. It is
Huh.
only
Here they've
OIA
used the word
last page to be
authenticated. No.
signed. No, authenticated. See, in this C state rules, in GST C state rules, they have clearly mentioned that they are not going to have any physical inward of any document.
Right.
तो
So it
जो
will
भी
be online
होगा
only.
आपका ऑनलाइन होगा, ठीक है.
हाँ.
Now just look to the APL1 versus STR5,
Right.
ST5. Right. Till now, as of now, also in our office, we are preparing APL1 in line with ST5, ST4 और versus ST5. मीन्स जो
हाँ,
हमारा
ST4
अपील
first step.
बनता है अभी तक,
हाँ.
we अपने we people have that practice to prepare entire set of documents in
Yes.
APL1. उसका आगे इंडेक्स बनता है, आगे उसका आपका कॉल्यूमनर फिल होता है. बट future going, there is no requirement to verify each and every document. I think so. Whenever appellate, they will be their appellate is formed. They are going to link GST portal with this C-State portal. जो document उनके चढ़ाए हुए हैं, you have to just put in your facts and grounds on appeal. All the documents should and must be carried forward as in from the GSTN portal directly.
But the rule does not say so.
But
And
नहीं
आप
नहीं,
जो बोल रहे हो
I
ना कि
totally
आप जो बोल रहे हो, see
sir.
the, that's what we are saying. See the words they have used or the documents received by the party. Order का तो आप छोड़ दो, ओरिजिनल अगर आप दे दो, डॉक्यूमेंट्स रिसीव बाय द पार्टी, मतलब जितना भी हम लोगों को मिल रहा है आरयूडी, सारे का तो फिर ऑथेंटिकेट करना पड़ेगा ना आपको.
Sir,
But
sir,
I think we'll
that
also
does
take
not
we'll take
mean
some other
each and
view also.
every page. Sir, just recently I received an order wherein
हाँ.
in a statement recorded by DGGI, they have mentioned that party have perused page number 1 to 6,000 pages. Please
हाँ, वही.
understand and
We also
appreciate.
have similar matters.
Correct. So that does not mean that party has gone through each and every 6,000 page. It was never required. It was never intended. So I think we should not stretch our interpretation to that extent कि अगर आपका फाइल 200 अगर आपका अपील 200 पेज का है या 2000
हाँ.
पेज का है तो एज अ रिप्रेजेंटेटिव you have to put a signature on 200 or 2000 pages.
Okay.
So that
So
is
I think
practically impossible. Practically impossible.
okay, Praveen, we take your point. Now I think we'll just take the other views. I think Soumya ma'am wanted to share something.
Yes, sir. Sir, when they have these documents are issued by the department itself, I mean,
Yes.
why is the requirement to do a certified copy of the same?
Nee, if you give the original, then no requirement.
No,
If
but
you give
now
the original
everything
show
is
cause
on the
notice.
portal itself, right? Nobody is getting any original copy. Everything is
Mhm.
posted on the portal only.
Right.
So in that case, it doesn't
No,
make
see,
sense
if
at all.
it's on the poster, if it's on the portal, if it's digitally signed, then there is no problem on this. Because it's already original then in that case. Here the discussion
Correct.
is where it is either uploaded on the portal without digital sign or you're getting the hard copies.
Yeah, that's the point. If it is
In mainly
digitally signed, I
DGGI
don't
matters.
think it require any
Investigation
certification.
matters. Like in
Yeah,
DGGI
right.
investigation matters where it's running into 1,000 pages. Because what Praveen ji is saying here, they are not saying about authenticating each page. But here they have also not mentioned, like, that because they are using the word of the documents received by the party or a copy
Right.
thereof.
Right.
I
Right.
think SK Malhotra sir, I think Arpit ji wants to share. Arpit ji, pehle we'll go to you, then we'll go to SK Malhotra sir.
Aruji, I think that while we are discussing the definition of certified copy,
Yes.
if we can go through the allied rules which provide for submission of the certified copy, then
Yes.
it would be a better case for discussion.
ठीक है, मिल जाता हूँ.
And secondly, even if I go by the wording what have been written, and to
Yes.
safeguard myself, only to safeguard myself, I am not analyzing in the legal perspective what would be the. I would be having two authorized representatives. First, they would be authorizing me to appear, and second, they would be authorizing their regular employee to sign the documents. Because this regular employee can be an authorized representative, so he can certify the documents, and I can appear on those signed documents to argue the case.
Yeah, that is a possibility.
So in that, and what we need to see that when an authorized representative can certify the documents, how can the assessee himself is not entitled to certify?
Yes, so that
Because-
is my main concern.
No,
That is what I'm trying to say. I'm trying to
question
say that
is-
only.
the question is that the assessee has delegated the authority to the authorized representative to appear on behalf of him. So someone, if he has been delegated some authority, how can the person who
Yes.
has delegated the authority cannot be entitled to sign them?
No, that
Because
is my
the
mood.
Section
That is
5,
my mood question, Arpit ji. Ki
if
here
we
the
see
wording
section-
should have been either the taxpayer or the authorized representative. बात खत्म
No.
हो जाता.
Yeah, if we see Section 5 of CGST
Yes.
Act, what it says
Yes.
that any authority which has been given to the subordinate authority, it is deemed
Right.
vested in the higher authority.
Mm-hmm.
So the AR is a delegated person. How can the person
Yes.
who is authorized a person cannot be entitled to certify them? So there is an inherent lack of understanding on the definition of certified copy, that a person who is delegating and asking someone to appear, he is not allowed to sign those documents. And secondly, if that is the case, then in such case, although I would not be signing those documents, I would be getting a employee to be the authorized representative, and he would be certifying those documents.
No, but yeah, my mood question is that only. Why is the name of the taxpayer not being given and
Yes.
only the authorized representative given? So I think that is the change that we should suggest. That please also incorporate the word taxpayer there.
No, it should
I mean,
be
the
because
party.
AR is a delegated representative. You cannot take the authority from the supposedly if a person wants to argue himself, he does not want to appoint any authorized representative. So whether he would not,
Right, then
in that case, who would sign those documents? The employee would sign those documents.
the employee, yeah, exactly. The employee also then that authorized signatory has to sign.
Yes,
Because
matlab,
the employee is
if
again
I am
authorized
a
representative.
now let's take a case. Myself being a chartered accountant wants to argue my firm's case myself.
Yes.
So who would be certifying those documents?
So that is, and this is a very funny bit that they have done
Yes,
on this. I don't know why.
Yes.
Suddenly.
And
It was never
if we-
there. I don't know where from they
whenever we
got
will
this idea.
discuss this the certified, then because this term is appearing in Rule 20 and 21. Certified copy.
Here. I've just taken it out. Yeah. RPG, देख, ये आ रहा है ना 20.
Yes.
Yeah, because my here it's saying internet connection is weak. Okay, anyway.
22
So
also,
every
sir.
form of appeal shall set forth concisely and under distinct head the grounds of appeal and such. Every form of appeal, cross objection, stay applications. This is there, and every form of appeal or application or cross objection shall be filed here. The appellant or the applicant or the respondent of the authorized representative shall certify as true copy the documents produced before the appellate tribunal. Here
Now,
they are saying
in
about the
this case-
options.
Yes. Now this Rule
But
20
here they're
Rule
again
3
saying
going beyond the definition
yes.
of certified copy.
So this is the definition. This is what they should have in the definition.
Sir, I
Simple.
think we should distinguish between authorized signatory and authorized representative.
No, here they've used the word authorized representative only.
Yeah, so
Sir,
that
the-
means it will be the CA
Yes.
only who's representing.
So Rule 22 is clear on that aspect, na, sir, because I think it is saying at the foot of every appeal or
Sorry.
pleading,
once.
along with all the relevant documents, including RUD, they shall appear the name and signature of the authorized representative, and every appeal or pleading shall be signed and verified by the party concerned in the manner provided. So I think
No,
somewhere
signed
Rule
and verified so is okay. Signed and verified so that is done by the party only.
20 so they are authenticating the document, na, sir.
Yes.
And one more point is in the certified copy, they have also said not only the copy of order, even they have said documents received by the party. So can't we
Yes.
look into that aspect also, sir? Because they have
Yeah,
referred
that's what we
original
were
copy of the
discussing. That
order. Yeah,
original copy of the order is okay, but the other documents like INS, summons, the RUDs.
yeah.
So
Can
all
we
the
not
things also have
include
to
in
be.
that?
Huh?
Yeah, sir. So those documents also we can format as part of that documents, na, sir, because they all are
Yes.
saying documents received by the party. So all those documents are received by the party, right? So I think
Right.
that's why at the end they have used only authenticated by the authorized representative.
Or
So I
RPG.
think
RPG again. See here,
Okay.
if you see
Yeah.
20 sub rule 3
Yes.
and again 22.
And
20
21
sub
is,
rule.
so the definition of certified copy is going beyond Rule 20, 21 and 22.
yes.
No. If you see the fun, see 23 is saying appellant or the applicant or the respondent or the authorized shall certify the true copy of the documents produced
Yes.
before the tribunal. Again, they're going to 22 as just shared by
Yes.
Annapurna ma'am. There they are saying it is authorized again. So I think what I'm trying to say is this particular dichotomy, it has to be presented now. Why
Yes.
I'm saying so, I'm saying so out of my concern, because many a times it happens that sometimes in the final moment, documents are given by the client, and we don't have the time. Okay, we have to file the appeal on, within the deadline, or else you have to go to high court and all those functions are there. So getting all this thing authenticated by us, it has an inherent risk. And if you see this entire rules also, they have themselves also confused, because after 20 sub rule 3, when they come to 22, they're saying again about there shall appear the name and signature of the authorized representative. So that means again here they are not concluding the part that the appellant can also authenticate the documents. So I think this particular definition along with the rules, they need to be stated and they need to be put in perspective before the authorities so that they can take cognizance of this and then frame the rules or change the rules wherever possible.
अरूप जी 22 को दोबारा देखिएगा 22 को प्लीज
हाँ सर, हाँ एक सेकंड सर, आप
22 में
बोलना
बहुत
चाहते
कुछ लिखा है 22 is really very डेंजरस बट 22 में लिखा है every document has to be name of the authorized representative should be there,
Name and signature.
name and signature. तो इसका मतलब whatsoever document we are attaching with the appeal, उसमें मेरा नाम और साइन चाहिए. इसमें रिप्रेजेंटेटिव लिखा है खाली. तो ये आरपी सर की बात ठीक है कि देयर शुड बी 2 authorized representative, one of the employee of the company and one we self. So we will be.
नहीं, उसमें भी I'll just go to like to revisit authorized representative का definition once again. Just one, give me 1 minute. मैं authorized representative definition में फिर से एक बार जाता हूँ. इसमें क्या बोल रहे हैं? Person authorized in writing or through वकालतनामा duly stamped by party. See, Arpit ji, the word used is by a party to present this case. तो employee तो present नहीं करेगा. फिर तो वो function he is not fulfilling. To present his case, to appear, plead or act on his behalf in such proceedings. So employee will not fulfill the definition of authorized representative. If he is doing it, then he has to appear also. But here, I am the person who is appearing.
A person
So
authorized in writing or through wakalatnama duly stamped by a party to present his case before as provided under section 116. So they are referring to.
No, that they're referring. But two things are here. Two things are there in this definition. First, by a party to present his case.
Yes.
तो present नहीं करेगा.
So he may appoint 2 persons to present the case. The employee can accompany. Supposedly now, if we go by this strict interpretation, supposedly there is a change of a counsel in between. So whether that will require
that is a different argument. That is a different discussion. But I'm saying where we know inherently that the employee is not going to appear. So will it not be a misstatement before the tribunal?
Why he is not? Why he can accompany? He can accompany to the court.
No, accompanying is a separate thing. Presenting his case is a separate thing.
No, again in that case, we are saying that one who argues can only sign. Supposedly,
yes, because in our Kolkata Sestat, we have seen very senior officials also being told about this. That if you are not arguing, you cannot stand there. You have to sit.
No.
Sir, may I? One thing I wish to highlight here. Sir, here it is written that as provided to appear. So what I understand is whoever is appearing, he should be authorized. But it is not essential that everyone who is authorized should appear.
Everyone who is authorized, but agar
should not appear. Sir, the person who is appearing or representing must be authorized. But it is not essential that everyone who is authorized should appear or represent. This is what I feel.
No, everyone should not.
Then that employee can be authorized.
But at
it
least
is not essential for him to appear.
But in that case, will the tribunal not raise a question that where is this person who has signed and authenticated the documents? Why is he not present in the case?
Sir, you can appoint multiple persons for the representation.
No.
Right?
My discussion
tribunal used to ask that whoever is appearing should be having authorization letter. They never asked that everyone who is having.
No. Here, that's what I'm saying. Here there is a marked departure. Here the tribunal can question, say, I am appearing before the tribunal and authentication is done by you. So tribunal may not question. The DR may raise this question that this person is appearing, but he has not signed.
No, sir, in that case, we can. In that case, there is an authorization letter also, no?
Arupji, supposedly, the example which you are taking earlier, that there are 3 partners in your firm.
Yes.
And all the wakalatnama has been issued for all the 3 partners.
Right.
Now, supposedly, one of your partners sign the document, attach the documents, and get it filed. Now you are appearing on that day.
Right.
So does that mean that those documents have to be also attested by you?
No, but at least the other partners are a partner of my firm. So here what is happening?
Again, we are only authorizing only individuals. We are not authorizing the firm. So if there are 3 individuals, there might be 3 different chartered accountants of the same firm, the different firms. Now, supposedly they are from the same firm, and one of them signs the document, submits the appeal, and other one appears. So it cannot be a question that where is the person who has signed those documents, because
in that case, since that's a practice, I think that will not be a problem. But in the case where employee is only signing and authorization is going, there may rise a problem. That's why I think this particular thing should be taken up right now only. नहीं तो बाद में लेकिन this will become a
That
challenge.
has to be taken that the certified copy, the scope has to be enlarged to include the proprietor also. Now, the
Yes,
case.
my only submission is that उसमें change कर दिए, बाकी कुछ नहीं करना पड़ेगा. Authorized representative जो है ठीक है, उसमें तो problem ही नहीं है.
And
Arup
they,
Das,
yes,
sir.
sir.
and they can be
Yes, sir.
understood
Sir,
from simple
yes,
case that a
sorry,
chartered
RPG,
accountant
RPG.
case has been made and he himself wants
Gurjit
to
sir,
argue.
one second. I think RPG, yeah, RPG बोलिए, RPG.
Now, the only I would also rest my case and support your contention. They only need to given one example that a CA firm case has been made out and the chartered accountant himself wants to argue.
Yes.
So very good will bring the authorized representative or a legal lawyer who wants to argue his firm own case.
Right. Gurjit sir, over to you, sir.
Yes, sir. I was just giving a different perspective on a lighter note.
हाँ
That
sir, हाँ
the definition which is coming on the screen for authorized representative, if you see the clause 1 regarding the government side, and with
Yes, sir.
reference to this, you see all those the sections and the certified copies which we are discussing about. So it is solved for them. It is not a problem. It is only the
No.
other side of the person where the issue is, because commissioner is not going to sign. There will always be an authorized representative. From
Yes.
their perspective, everything is hunky and dory. No issues.
Right. Right. Yes, that's also a good point. Okay, I think so. Now we'll move ahead of certified.
Arupji,
there are only 10 minutes left. So I would like to take one more question.
हाँ बोलिए.
Regarding the fees to be deposited with the appellate tribunal for filing of appeal.
बोलिए. I'll go to the rules.
Yes. And I would like to seek, because we only 10 minutes are left, so everyone can go through and see it.
नहीं इसमें नहीं अर्पित जी 2-3 चीज और था. एक था ये, but I think this is just the first that group discussion that you are having on tribunal. I'm sure we'll be having more. But Arpit ji, I wanted to also discuss on this interlocutory application. Or I'll go to the fees. 1 second.
No, you can go ahead. We can.
Another interesting thing is about that warrant. There are many interesting things brought in here. Like listing of the cases will come, 12 hours. So, achha. So can you discuss about that then? एक बार अर्पित जी.
Yes, if you can share rule 110. Rule 110 sub rule 5.
चले जाते हैं एकदम साथ.
No, not of these rules. CGST rules.
Oh, that's what I see. CGST rules. Yes, I can go. 1 second. Just give me 1 minute. रूल्स में जाते हैं. यहाँ पे वारंट के बारे में भी बोला है. दैट इज वेरी इंटरेस्टिंग कि कोई अगर नहीं आ रहा उसको थाना में बुला के फिर लेके आना पड़ेगा. ऑल दोस क्रॉस एग्जामिनेशन मैटर्स. हम लोग चिल्ला रहे हैं क्रॉस एग्जामिनेशन करने दीजिए फेक क्रेड के मैटर्स में. सो इफ द ट्रक ड्राइवर्स दे डोंट कम, दे विल बी नाउ सेंट अ वारंट कि आप आओ.
ओके.
हाँ. अच्छा, I have to share, sorry. $105 बोल रहे ना?
111.
Sorry.
110.
Arpit ji.
Yes, ma'am.
And any particular reason like why these rules are kept separate? I mean, outside of the CGST rules.
That was what I was thinking also. That why they have been notified separately from CGST rules.
No, that's always there. Even ITAT rules and everything is separate.
It has to be separate, no? How can it be part of that? So, because it is a separate adjudicating body.
So they will be governed separately.
Yeah. Website cannot also be the same of GSTN. It's an independent of GST Act.
That's why we are having a separate portal also. Yes, Arpit ji, आगे.
Yes.
110.
110.5.
110.5. Yes. Yeah. The
Now
fees
the
for yes.
The fees for filing of appeal or restoration of appeal shall be 1,000 rupees for every 1 lakh of tax. or ITC involved, or the difference in tax, or ITC involved, or the amount of fine, fees, or penalty determined in order appealed against, subject to a maximum of 25,000 rupees and minimum of 5,000 rupees.
Huh.
So 1,000 for every lakh and 25,000 maximum.
Maximum.
Now this is for CGST only.
Huh.
They would be separate
Yes.
for SGST.
Yes.
And twice of that for IGST.
Huh.
And 25,000 for cess.
20,000 for cess, right?
So if there is a demand involving CSI and cess, and even if we keep aside cess, so the demand for CS and I, so the minimum filing fees would be 1 lakh rupees. Because as also the officers don't seem very satisfied for only few lakh of demand. Nowadays we are facing a crore demand easily.
Crore. अभी तो crore के नीचे कुछ नहीं है.
हाँ. So for every 1 lakh rupees, for every 1 lakh rupees of tax, there is a appeal fees of 1,000 rupees, which I feel that it is making the appellate tribunal a profit-making body.
Self-reliant.
आरती जी,
Yes.
इसमें टैक्स के बेसिस पे तो ठीक है, but ITC is a terminology which includes ITC of each and every tax, central GST or state GST. Okay. So टैक्स का पॉइंट ऑफ व्यू से तो आप ठीक ही कह रहे हो, बट IGS जहाँ ITC का पॉइंट होगा,
हाँ,
वहाँ फीस से जो डबल वाला जो इफेक्ट है ना, वो नहीं होगा.
देखिए वो तो ऐसी चीज है कि अपन जब 73 के प्रोविजन लगाते हैं तो सब चीजें सेपरेट ही चलती हैं. नहीं, मैं what I was trying to say is I want to see take the views of the house that how the fees would be calculated, and if the issue is such grave that it would be calculated separately of CS and I, then this is the issue which needs to be taken up immediately.
Yes. क्योंकि अब तक रूल्स नहीं आए थे, हम लोग ने इसमें भी ध्यान नहीं दिया. That is one more aspect.
Because if I go by the views of Vivek ji also, then also cess would be having a separate fees.
Yeah, for cess it will be separate.
So
Arup ji,
about this fee structure.
Yes, sir.
Arup ji, this is in relation to fees. You have correctly said that we have not looked into this provision.
हाँ.
RPG has looked. ये फीस के लिए बात कर रहे हैं या प्री डिपॉजिट के लिए बात कर रहे हैं?
फीस.
सर, पर ये फीस, सर, how can fees be linked with the tax CSI cess?
वो तो अभी
भी ट्राइब्यूनल के अंदर 5,000, 10,000, the fee structure is different, and RPG is very right. If fees is been decided in line with pre-deposit, then this is a very serious nature
not
of thing
not
to
pre-deposit,
be.
the demand.
No.
Demand.
If fees has been treated in line with pre-deposit, then this is a very serious matter which we need to represent on priority basis.
Yes.
Because it seems
fees can never be.
It seems that what they have done is that they have made tribunal members as a person who had to earn their salary and then get the salary.
Sir, but I think we need to look at Section 20 of IGST. In initial, just since you brought up this point, I was looking at. We need to study it before commenting it.
Section
like this.
20.
You must have studied it. Yeah, it doesn't. It says for penalty that it has to be double. Even the sections which will be relevant from taken from CGST, things about fee is not mentioned there. Hope that has been looked thoroughly.
This aspect I have not seen.
Sir, I think they have referred appeals and revision. So I think that will take care of fees also, no, sir? Section 20.
Yes, okay, yeah. That can be from appeal and revision. It can be considered
that
fees
can be.
also part of that.
Yeah. I am not able to see anything on the left side. Are you able to see and you are navigating?
No, I can see. But then left side you can't see anything. वो मैंने हाइड करके रख दिया लास्ट की there is some problem with this side. So this is 20. Gurjit sir.
Sub-rule 19.
Yes, sir. Ma'am is saying that appeal and revision
Yes,
is there,
appeal and revision
so
is
fee
19.
can be taken part of this. That is at 19. But then the further provisos which are there, proviso regarding penalty does say that the amount has to be double. Regarding fee, I think there's nothing specifically mentioned.
Yes.
Ravjit, this is something for to be thought about in the next week, and for the next SMS, we would be continuing with the SMS on tribunal rules only. So
नहीं
this
नहीं
was a
Yeah, no, next week we have a different plan. We already
But,
have
But
but
continue.
for fees there is a maximum limit, sir. 25,000.
25,000. Yes.
But sir,
25,000
what
is the maximum.
what RPG is saying that even if maximum limit 25,000 is there, if we take it for 4 acts, it will become 1 lakh rupees. So very high cost. That is the approach of the government for quite a few years. Even in service tax, it was like this, that they have been raising the fee to very high levels, making it very difficult to approach for justice. That is the point Arpit sir is making.
Okay.
The detailing we can discuss, but the point is very much relevant, sir. I also agree with him.
Yes, I think this is something that we need to represent at Pijab. That is there. And in between, I think we can go through the.
Arujji, your voice is echoing.
अभी कर रहे क्या?
Echo हो रही है आपकी आवाज. Yes.
अभी भी. Hopefully that will be okay.
It is matching the personality, that is why.
What we want to request to all the friends is that, let's all go through the guest appellate tribunal rules. And as we can see, there are a lot of conflicting things already. Because आज जाके अगर गवर्नमेंट को बोलेंगे जब तक ट्राइब्यूनल आ जाएगा शायद चेंजेस हो जाएंगे. लेकिन ट्राइब्यूनल आने के बाद this may become a point of contention because of the place of challenge also. So
it's
I
the time
think,
to close the session.
Yes, so this is the time to close the session. And but yeah, before closing the session, I'd like to share that whatever concerns we have, maybe we can start putting in the group. And as we have our system head, Venuji, he can prepare a Google Doc where you can put all the things together. And then maybe as from the faculty group, we can make a representation. That's one of the ideas. I think we can take it out for the first time.
Yeah. So definitely it's a good initiative that we started scratching, understanding the rules of the tribunal. And what we will do is every month, first week, we will take up on update session. Updates for the month or whatever be the general topic. And then we will continue with the regular section readings. We have completed till 30, but there is small part 2 of the 29-30 is required. And part 3 of 31 is required. So next week we will have 31 continuation from Anuji.
Next week is RCM. I'll just share the calendar. Next week is RCM.
RCM. Okay.
Two young dynamic speakers from Pune.
Okay.
And Maheshji. They will be sharing.
Good. Then we'll continue after that. Yeah. So Arupji, special thanks for filling in. So and no, the last minute discussions and you jumped in. That's nice of you. And members, I would again request give your name so that it would be easy for us to schedule. Otherwise, most of the time we will spend in okay, agle hafta kya karenge, kaun karega, all those things are happening. So we want everyone to volunteer and contribute for the discussions. With this, we will end today's session. Thank you, Arupji, Arpitji, and others. Thank you. Bye-bye.
Thank you. Yes, bye.